You guys ready?
Yeah.
Alrighty, we're ready to start. And welcome to the fourth panel, last but certainly not least, and it's on the topic of national security and rights. And my name is Beth Simmons. I'm here at the University of Pennsylvania. I will, first of all, remember to say what the code word is. It is, the code word is covert. Covert. Alrighty, so let me introduce quickly who our panelists are today. First of all, we have Ashley Deeks from the University of Virginia, and she'll be presenting a paper on subdelegating national security powers. And Ashley is the class of 1948 professor of scholarly research in law at the University of Virginia. She served in various roles within the State Department's Office of the Legal Advisor, including the Assistant Legal Advisor for the Office of Political Military Affairs. And her research focuses on international law, national security, intelligence, and the laws of war. Second, then we also have a paper that is co-authored. It's a co-authored paper on the President's authority over cross-border data flows. This is an opportunity to talk about TikTok, and I'm sure we'll get a lot of interesting questions about that from our audience. And we have two authors on this paper. One is Anupam Chander, and he is from Georgetown. He is the Scott K. Ginsburg Professor of Law and Technology at Georgetown University Law Center. He's an expert in global regulation of new technologies. He founded the International Law and Technology Interest Group of the American Society for International Law and serves on ASIL's executive committee as well. And he's co-authoring with Paul Schwartz, who is here also. And Paul is the Jefferson E. Peyser Professor of Law at Berkeley. He co-directs the Berkeley Center for Law and Technology. And he's an internationally recognized expert on information privacy and information law, and has advised various international organizations, corporations, and law firms in that area. Currently, he is co-reporter for the Data Privacy Principles Project of the American Law Institute. And then we have Chris Mirasola from Harvard on the end. He's a Climenko Fellow and a lecturer in law at Harvard Law School. His scholarship and teaching draws on his prior public service as an attorney advisor at the Department of Defense, and his research interests are in national security and international law. So, thank you all for being here, and thank you so much to the organizers for making this really, I think, a rich and wonderful day for all of us and for all the participants as well. I really appreciate you coming to the University of Pennsylvania. So, we'll start with Ashley, and she'll present her paper about subdelegating.
About subdelegations. Thank you, Beth. As everybody else has said, thank you to the Law Review. All of the work you guys have put in has been really amazing. And thank you to all of you who are here watching us bat cleanup. We thought about whether everyone should get up and do some jumping jacks to get the blood flowing. But hopefully we'll be talking about covert things and TikTok, and that should be good enough. I decided to focus my contribution on something that during my most recent time in government had come to my attention, and that's the complexity surrounding national security delegations. And so by that, I'm actually referring to delegations within the executive branch, often down from the president, down the chain of command. It turns out that very significant decisions at least have the possibility of being delegated pretty far down out into the field to officials who are serving out there. There is no one repository of presidential delegations. There's no secret file, as far as I'm aware, that contains all of the delegations that presidents have made over time, which means that a new president coming in may actually have little understanding of what delegations his or her predecessor have made. And there is nothing apparent that formally constrains at least the president's constitutional delegations, that is, delegations of his constitutional power. And yet, of course, as we know, the president has very limited time. Trying to get on the president's schedule is almost impossible, from what I am told. So there are very discrete numbers of issues that he actually has the bandwidth to decide himself. So I am interested in this tension between, on the one hand, the necessity of delegating a lot of national security activities down to different national security agencies and then on down inside those agencies, and at the same time expecting the president to make the most significant national security and foreign policy decisions, many of which we've heard other panels talk about today. I also saw a couple of situations in which an agency pushed back a little bit on a president wanting to potentially revisit a delegation that had been made, so an existing delegation. Another complication is that national security subdelegations are very often classified. So it is hard for the public to know who is making these significant decisions. Finally, I'm interested in this because I think that subdelegation doctrine is potentially going to be quite important in the future of our warfighting, as we move to conflicts that are sometimes described as being at the speed of hyperwar, where there may be questions about whether the president can actually subdelegate decision-making to machines, machines that would engage in autonomous action. So I will briefly set out what I understand to be the current legal framework related to subdelegations. I want to highlight some possible costs that I think arise from national security subdelegations, give you a couple of high-profile examples of the kinds of subdelegations that I'm talking about, including two areas where I don't think we have ever seen subdelegations, and I want to think a little bit about why that might be the case, and then just a couple of tentative legal conclusions. But at this point, I'm still trying to map the legal landscape, so very much look forward to people's thoughts and comments about things I'm missing as I'm trying to do this mapping. So what is the current legal framework about subdelegations? So I think we have to think about this in two buckets. One bucket is constitutional subdelegations, delegating the president's own constitutional powers, and the other is delegating statutory authorities that he's already been delegated. So the one actor who spent the most time, I think, writing about constitutional subdelegations is the Office of Legal Counsel, including as far back as 1855, when what was then the Attorney General would write these kinds of opinions. And the OLC baseline seems to be that the president has broad authority to delegate constitutional powers, but certain functions are not delegable. OLC has an opinion about whether the commander-in-chief power is delegable, and I'm still trying to puzzle through it. What it basically says is that the president cannot delegate his commander-in-chief powers, but, quote, he may make formal or informal arrangements with his civilian and military subordinates in order to ensure that the chain of command will function swiftly and effectively in time of crisis. So it seems like the president could delegate, for example, to the Secretary of Defense, or maybe the commander of the Joint Chiefs of Staff or combatant commands, his repel attacks power. On the statutory front, Congress has actually embraced the idea that the president is going to subdelegate lots of his powers. There's a statute, 3 U.S.C. 301, that is not specific to national security, that basically says that the president can delegate to a Senate-confirmed official any statutory function. It has to be in writing, and it is expected to be published in the Federal Register. And there's an exception, which is that the law might affirmatively prohibit delegation, in which case the powers in 3 U.S.C. 301 would not attach. Maybe not surprisingly, the Office of Legal Counsel has interpreted the congressional prohibitions narrowly, but they do concede that there are 3 situations in which the president cannot subdelegate his statutory authority.
The first is where the Congress envisions the president acting by proclamation, because the understanding is that only the president can issue a proclamation. The second OLC says is where the function involved might be of such fundamental gravity as to render inescapable the conclusion that Congress would not have created the function but for the assumption that the president would exercise it personally. And the third, which I think will be particularly interesting to Professor Bradley, is OLC says where the president has traditionally not delegated a particular authority, the gloss that arises from that non-delegation, from that historical practice, might foreclose future delegation of that authority. And that's interesting because largely the executive branch, what you see the executive doing here is conceding that an inaction by the executive might accrue gloss against it having certain powers in the future. Okay, so why am I worried? Why should we be worried about national security subdelegations at all? How could they go wrong? What could go wrong? I think there are a range of reasons to worry, and I think some of these reasons are unique to the national security setting. Some are not. Some are sort of generic delegation questions. The first is that where the subdelegations are classified, which, as I submit, is a lot of these national security subdelegations, it obscures the decision maker's identity, especially ex ante, but maybe for longer than that. So a surprising example, some of you may have read about this, is that President Eisenhower delegated to 7 military officials powers to launch nuclear weapons, pre-delegations. I think most of us would expect that the president himself would make such a significant decision as to launch a nuke. I think the other thing that I referenced in my intro, but is also surprising when we're thinking about obscuring the decision maker's identity, is that it's the president himself who might be unaware that his subordinates are taking certain decisions because there's a pre-existing delegation of which he's unaware. So that's the first reason, obscuring the identity of the decision maker. The second is that decisions could be of inferior quality, or they might be unfaithful to the delegator's intent. Some of you may have studied the case Little versus Bareem. This is a case in which the president ends up delegating authority, or the Secretary of the Navy ends up delegating authority that Congress hadn't in fact given, extended a delegation that exceeded the statutory authority. Another concern is that a delegee who is down the chain, out in the field, in a single agency, will often have a more limited perspective, a more limited understanding, a more limited set of information about a given foreign policy or national security situation than the president would have from his perch in the White House. Also in this bucket, Congress may expect that the president himself would exercise a particular authority that they delegate to him. So here, think about something like the authorizations for the use of military force that we've heard about on a number of panels. It might be that Congress has in mind that it will be the president that is exercising that statutory authority when they enact that kind of statute. Third concern is potentially decreasing the decision-making quality when the subdelegation eliminates an interagency process. And what I mean by that is, if a president is subdelegating to a single actor in an agency, that is empowering that actor in that agency to make the decision. And that generally means that that actor, that agency, is accruing power and potentially cutting out other agency actors from other agencies who feel as though they might have valuable information to bring to that debate. If the president hadn't subdelegated that, it would have gone up to the president, and the agencies collectively would have had the ability to feed in their views. And the fourth concern, again, which I think this one is unique to the national security subdelegations, is that it can really undercut civilian control of the military. That is a problem because it might hasten us to war, especially if we think that military officials have different mindsets from civilians. And there have been some writers who have suggested that that is the case. Okay, are there any high-profile examples? There are a couple I want to flag for you. The first is the nuclear weapons example that I mentioned with President Eisenhower. So he pre-delegated this authority to the 7 actors, and the way he did it and the way in which he tried to convey his instructions is pretty interesting. But I think current practice seems to have unwound that particular subdelegation. That has the cost that I've identified, right? That's the Congress and the public were unaware of who the decision maker would have been in that case. There were concerns about inferior decision making by those 7 military officials who had received the delegation. There are historical reports about one of the delegates actually being somewhat unstable, and his own subordinates were worried that he was in possession of this power. And there you also see loss of civilian control of the ultimate decision. Another example, this is more contemporary, has to do with offensive cyber operations. And maybe you guys have read about this in the news. President Trump reportedly delegated a fair amount of authority to use offensive cyber operations, both to the CIA and to the Defense Department. So for the CIA, if this was done via a covert action process, then Congress would have been informed because there's a statutory regime for that. But congressional committees apparently fought for a year to try to get a hold of the Defense Department's received delegation, the process by which they were going to be allowed to engage in offensive cyber operations. Congress and some in the executive expressed concerns about the decisional quality that might have resulted, or that did result from that delegation. Unclear, I think, whether the military would have had the full foreign relations context when deciding whether to undertake an offensive military operation. Again, we see a shift here from civilian to military control. A couple other examples that I'll just name. One is the targeted killings process. There have been some delegations there. The freedom of navigation operations, which are naval operations where the U.S. Navy will sail through a particular area that it perceives as being international waters, but others may claim for their own, as their own territorial waters, so that can be provocative. And finally, designating certain foreign forces as hostile. Those all implicate subdelegations, and I think they all have high potential for bringing the U.S. into conflict with other states. Quickly, 2 cases in which we have not seen subdelegations of statutory authority. One is where the authorization for the use of military force to the president envisions that the president will make certain findings or determinations before activating the power. We see that in the 1991 authorization for the use of military force in Iraq, the 2002 authorization, also for Iraq. The second area where we have not seen a subdelegation, at least not one that's been made public, is signing covert action findings. It might be, why haven't we seen this? It might be that the president wants to make these decisions himself. It might be because he thinks that Congress has a clear expectation that he will be the person making the decisions. Or it might be because gloss has now accrued and actors inside the executive branch are advising that he either cannot or should not delegate those powers down. So where is the law now? And could Congress or could the president change this legal landscape that I have tried to describe? So I think it stands that the president can delegate his constitutional repel a tax power if there's no statute prohibiting him from doing it. I would suggest that the more tenuous or complicated his constitutional power to act, the more tenuous his ability to subdelegate that power. On the statutory subdelegation landscape, it might be that he is no longer able to subdelegate AUMF or covert action powers if he ever could because of the gloss or congressional intent. It's also worth noting that Congress itself has enacted a few statutes that weigh in on subdelegations. There is a statute about cyber operations that requires the Secretary of Defense to report to Congress about any subdelegations that the Secretary of Defense has received from the President. There's also a different statute that prevents the Secretary of Defense from subdelegating certain financial authorities related to foreign proxy forces.
And the president seems to have complied with these, even though, as you may remember, the OLC has set a relatively high bar for how it's going to interpret purported non-delegation language. So I think Congress has a roadmap now if it wants to impose prohibitions on subdelegations or if it wants to make sure that it receives notice, even for classified subdelegations, from the president or from other senior officials. It could also identify in future statutes, such as in the next authorization for the use of military force, that Congress thinks the decision here is of such fundamental gravity that it does not expect the president to delegate that. The president also could do some things here. President could, at the start of an administration, require each national security agency to send in to the White House all of the delegations that are out there. So at least his administration coming in becomes aware of what his predecessors had delegated. And sitting presidents could, of course, sunset their own subdelegations so that they would expire at the end of an administration. So there's more to say and I think more to learn about national security subdelegations, but hopefully this starts the conversation.
Very good. Can I ask a quick question just for clarification?
Sure.
And that is around this idea of, you mentioned there's no repository of where you can find all the delegations and go look them up and code them and all that kind of thing. But I guess what I'm wondering is, what's your sense of the kind of lay of the land of institutional knowledge? And you talked about the president not having much sort of sense of what past delegations have been, but does the bureaucracy, does the military, do you have a sense of that?
So surely they do, because they're the ones who are ostensibly benefiting from it. But I found a very interesting set of documents on the CIA's website where there are a number of memos expressing confusion about what the overall principles should be with regard to further subdelegations of authority, and also a concern that things had gotten confused, that sometimes subdelegations weren't in writing, so a self-critical memo. So one of the benefits for a president to ask the agencies to put forward the delegations would also redound to the housekeeping, I think, of the agencies. It would be a major endeavor, I think, but could be valuable.
Very good. Thank you very much. All right, now we turn to the paper on President's authority over cross-border data flows, and I'm not sure if Anupam is going to go first or Paul is going to go first.
I'm going to kick it off.
All righty.
And so let me kick it off. Let me start by thanking Professor Jack Goldsmith and Professor Curtis Bradley and the UPenn Law Review for putting together this magnificent symposium. And I'd also like to thank the scholars in this room. This has been a new area of law for me, and your work has truly inspired and educated me. The next thing that I'd like to mention is, as was said in the introduction, the paper focuses on TikTok. And we did that for two reasons, Anupam and I. The first is so that our children and our students would think that we are a lot cooler than we are. The second reason was because we thought that the policy discussions about TikTok provided a great window into the question of the president's authority over cross-border data flows. It was just the perfect place to take it on. Our paper then, to kind of set this up at 30,000 feet, looks at two aspects of the topic that we think are unique to TikTok and other foreign-owned apps and platforms, such as WeChat, which are the question of propaganda and the question of personal information. So propaganda, right, the notion is this is a little bit different than the concerns during the Cold War about propaganda, because we now have propaganda that can be personalized, that can draw on PII, personally identifiable information, and algorithmic magic to have very targeted foreign propaganda. The second concern in the paper is personal data. And so does it mean that every time you use a foreign-owned platform that there may be an international data transfer implied in your logging on and uploading something. And so then final introductory point is what we're also trying to get at here is how we think personal data, digital data flows now change other areas of law. So a previous paper of ours looked at entitled Trade and or Privacy. And so we thought about how in that paper, how trade law impacts information privacy law and vice versa. In this paper, we're trying to think about how national security law and foreign affairs power may change, alter information privacy law and vice versa. And one of the really takeaways here is everything is data. Everything is right, and a lot of that is now personally identified information. And so information privacy law then necessarily becomes a discipline that cuts across many other disciplines or legal topics. And so then this influence back and forth, we think, is having a profound impact on unexpected areas of law, such as national security law and the foreign affairs power. And so with that, I will turn it over to Anupam.
Thanks very much, Paul. So recall March 23rd, 2023. Shou Chew, the CEO of TikTok, goes before Congress for the first time. He spends the next 5 hours being berated by both sides of the House, being accused of corrupting American youth, of being a Trojan horse for the Communist Chinese Party. Shou Chew himself is an elegant and composed Singaporean, educated at Harvard Business School, married to a Taiwanese American. Now he finds himself before Congress members who said permitting TikTok into the U.S. was like allowing the Soviet Union to produce Saturday morning cartoons. If your only picture of TikTok came from this hearing, you might end up believing that TikTok is a cesspool of communist propaganda and a place where kids go to get drugs. TikTok, we were told, and if you could go to the next slide, is the spy balloon in your pocket, one congressional chair said. And I might add, the spy balloon, just if you followed the news, because the New York Times reported the spy balloon as a spy balloon for the week, carrying it above the headlines, but it failed to report the U.S. military's conclusion that it wasn't actually spying over the U.S. mainland. That was buried deep in the paper. Just FYI, as information and misinformation campaigns go, how we ourselves are kind of what we understand about the world is itself always needs to be reviewed with more care. One congressperson noted, in China, the CCP proactively prohibits this kind of content. I watched all 5 hours of this hearing in shock at the McCarthyite treatment that this business person was receiving. And I tweeted acerbically, well, we could certainly adopt Chinese government practices of inculcating the proper citizenship values, right? Okay, so I'm going to turn back to Paul and come back.
Okay. So do you want to talk about the...
Oh, this right here? Okay, yeah, okay. Good, sorry, we're going back and forth. I wasn't sure. Okay, let's go to the next slide then. So everyone is very familiar with CFIUS and IEPA, so we won't cover that ground here. Except I will mention quickly that, of course, CFIUS, the Exxon-Florio Amendment in 1988, was passed to respond to the national security emergency that was perceived in 1988, which was the Japanese investments into the United States. Just a reminder of that history. Okay, so what I want to do with this slide is try to show you that the Trump administration began building the tools to erect a great firewall of the United States. And the Biden administration has embraced and even strengthened adding bricks to that firewall. Okay, so I'll just look at this slides very quickly. Beginning with Executive Order 13873 in May 2019, securing the information and communications technology and services supply chain. So one of the kind of, I think, problematic aspects of this whole area is how it's written in the language of very technical details about things like the supply chain. But if you read the text of these rules, they're basically any information service, any computer. It doesn't have to be part of a supply chain. When you think of the supply chain, you're thinking about long kind of steps along the way. But this is really anything that interfaces with Americans. So it's an odd use of the term supply chain. It's not what we international economic lawyers would describe typically as our understanding of a supply chain. Okay. So this EO has concerns about ICT technology and services. So this is not just about hardware, it's very much about software as well. And in September 2019, the OIS, Treasury issues regs under FIRMA, which has already been mentioned. FIRMA in 2018 is the congressional statutory authorization here to really expand CFIUS jurisdiction to clearly cover personal data. And that, of course, is a sensible move by Congress, I think, at the time. And fast forward to August 2020, when all of this comes to a head, with Donald Trump announcing the TikTok and WeChat bans. First invoking IEPA, and then a week later invoking CFIUS. In 2021, so as you probably know, during that time, what happens in late 2020 is the challenges to these TikTok and WeChat bans. These challenges are successful in the district courts, largely because of the informational materials exception to IEPA, essentially saying that the president never had the statutory authorization he claimed to regulate these kinds of information services. Also in the WeChat ban, that was actually struck down on First Amendment grounds directly in a district court. And let me just, I'm sorry, I'm mindful of my time here. There's the January 2021 Trump administration's time is running down. But before it goes out the door, it bans a half dozen new apps, Alipay, WePay, and a few other apps, again citing IEPA. And then it rolls out the final version of the ICTS supply chain rule, the Information and Communication Technology and Services Supply Chain Rule, on January 19th, just 24 hours to go. So this has very broad powers that it gives to Commerce to regulate information and technology services in which a foreign adversary has a possible role. Enter Joe Biden a couple days later, and the question was, what would he do with this? Well, Biden then allows the supply chain rule to take effect in March, and in June reverses, of course, the app bans. In reversing the app bans, he issues a new executive order on protecting American sensitive data. That requires the Secretary of Commerce to evaluate, quote, the threat of connected software applications. Connected software applications, by the way, that's every piece of software that exists, right? And he notes at the time that the federal government should evaluate these threats through rigorous evidence-based analysis, which seems to be a hint that the last administration didn't follow that procedure. And I'm going to turn it over to Paul.
Thank you. And we'll go to the next slide. So what's going on here? And so one of the things then that we, could you advance this one? Okay, perfect.
It's up.
Oh, it's up
on there.
Oh, okay. It's not on the monitor. Okay.
Okay.
So,
Yeah, the monitor and that are not
yeah,
linked,
no problem.
which is weird.
So one thing going on is that when we lined up the statutory authorities, what Congress has granted the president, when we looked at the executive orders, one thing that we predict for the future is there's likely to be a shift from IEPA to CFIUS due to the information materials exception. And so we kind of drill down into that in the paper. It is really quite broad and is, I think, going to be taken increasingly seriously by federal courts if there's litigation against some of the executive order and regulations that depend on it. But as we also predict, unclear to what extent that's going to represent any kind of victory long-term for litigants, because in CFIUS, as amended by Firmer, Congress quite explicitly gave the president sweeping authority to regulate sensitive information defined extremely broadly through the CFIUS process. So what happens then as we look into our crystal ball? One of the things that we talk about in the paper is then the rise of group privacy and implications. So something really interesting is happening here. What's happening is we are shifting into how we consider information privacy in this area of law. So privacy is viewed as a kind of group interest, as a national security interest, as a kind of public good. I think it's like Aesop's fable of the sticks. So the notion is if all the sticks are bound together, all those individual privacy interests, it will be stronger, and it'll be stronger for purposes of national security. So essentially the government is saying, let us protect you against TikTok, your personal data that's being collected by TikTok, and let us do it whether or not you want us to. So today, the Wall Street Journal reports regarding the Montana ban that this approach, Montana proposed ban on TikTok, that this proposed approach may be problematic. The federal judge challenged the state's assertion that the law protects residents' privacy, saying doing that confused him. Why? TikTok users share their data with the company voluntarily, and the federal judge said that's sort of a paternalistic argument. But when you get to Firmer and CFIUS, it's essentially a national security argument. Loose lips sink ships, as they used to say in World War II, right? And here, be careful with whom you share your data with. The national security is at risk. So lots of interesting problems here, or issues, one of which is, as we argue, this is a very under-inclusive approach if you're worried about personal privacy as a group interest, because the Chinese government or a foreign adversary can go to a data broker, they can target ads on a platform. So it seems in the absence of a federal privacy law to be a, we could say, strange approach if this is the policy issue on people's mind. Another problem, the definition of personal data in the regulations that we look at and the laws that we look at is sprawling. And so we have to think about whether or not that is going to be problematic. And then finally, very quickly, we also identify a number of constitutional constraints in this area. So yes, Congress, through Firmer, may have assigned very broad power to the president, but as we go through in the paper, both on the propaganda issue and on the personal privacy issue, we think this is going to be challenged probably more successfully under First Amendment grounds than due process. And now our last slide, and back to Anupam.
Great. And I won't, I'll be very quick here. So we propose a variety of steps that are designed to ensure due process and special concerns for protecting free expression in this context. And so we think that, for example, the CFIUS process is extremely closed. There's no public explanations, et cetera. We believe that there should be more presentation of this kind of evidence when you are trying to ban an information app used by 150 million Americans. And a judicial process that should be available to test the government's foreign threat claims and questions about secrecy and security can be met by various other processes that might be created, including proxies, et cetera, to receive that information. So we think there's a lot of concern to be had here. We might also I'll just mention very quickly Project Texas, which is the current mitigation measure that the TikTok is engaged with CFIUS. It alarmingly puts the U.S. government essentially choosing the directors of a private platform, including which is making the decisions about the algorithm and has access to all the data of the users. So it's a remarkable kind of replacement of the specter of China gathering data and compelling the algorithm, and replacing it with the real reality of the United States demanding that right, instituting that right, making the decisions as to who is going to sit astride the information flow that happens on this massive social media app. And we'll leave it at that. Great, thanks.
Can I ask you just a quick clarifying question? You didn't use the word big data in this presentation, and you did in your paper. And I guess, this whole question of the privacy, secrecy nexus seems a little puzzling to me. It does seem like sort of the privacy issue is a weird way to back into a national security argument. It seems to me like the obvious way in is the strategic use of information as a national security resource on the scale of huge data, right? It seems to me that's the national security concern here, not the privacy issue somehow. But maybe I don't understand.
So that's a great point. This has been raised in contexts that don't involve personally identifiable information. And so the example would be Chinese manufactured drones being sold to farmers, as well as other Chinese farm equipment. And so that can generate lots of very strategic big data type information about things like the harvest and harvest conditions and so on. So definitely a kind of a strategic issue. The problem is, I think in that, again, it seems like an under-inclusive approach. If the Chinese government can either draw on spy satellites that it has or just buy the information on the marketplace. So maybe an issue, we should also work in. We're really mostly in this paper interested in this kind of focus on personal data, and in the back of our minds, to what extent is this a kind of moral panic or not? Similar to in the 1950s, Congress being very worried about comic books of the day. And now today, those comic books like DC Comics are worth thousands of dollars if in good condition, and are the source for all kinds of movies and TV shows because they're viewed as classics. So we're really, for that reason, I think, trying to focus on, what is different when the concern is about this personal data. And I think one of the, like as I said, this algorithmic intensity. So where we used to just be worried about the Peking Review being sold in the U.S., Now we're worried about you get your targeted Beijing review, and it's going to be drawing on the kinds of videos that you have demonstrated you like to look at. You, right, audience of one. And then the other issue, as I mentioned, is that any use of the app involves your information going abroad, and so there's this general concern in Washington about personal information transfers, including, post-OPM data breach. So just a concern about, what's the potential now for blackmail?
Okay, terrific. And now we turn it over to Chris.
Thank you very much. Oh, boy. Okay. I think I'm the last person to say thank you to everyone for having me here. So thank you, everyone, for having me here. Two fantastic papers. I'm going to have just two points for each so that hopefully we have a little bit of time for folks to ask some questions. Ashley always does a great job of picking scab wounds from my time in government service, and so the first kind of question that came to my mind when reading your paper was whether an executive branch lawyer, whether a DoD lawyer, would think of all of the examples of subdelegation that you go through as subdelegations. So one example that came to mind to me as I was going through was the standing rules of engagement. So I found a declassified one that must have been FOIA'd or something, and so I found it online, right? And so the instruction says that unit commanders always retain the inherent right and obligation to exercise unit self-defense in response to a hostile act or demonstrated hostile intent. To me, if I was the DoD lawyer drafting this language, I'm not sure I would think that that's a delegation of any authority from a higher echelon, whether military or civilian. And so it seems to me that we might be dealing with two different things here. Subdelegations within the Department of Defense, for example, and at the same time, this other layer of a theory of inherent powers that inhere at these lower levels. And so if that's true, then arguably the kind of normative conundrum that we're dealing with in the paper is it's exacerbated, right? Because we have a question of, okay, where is the upper outer limit of these theories of individual inherent authority, right? Where does that peter out, if anywhere? And then I think it kind of complicates how we might think about mitigating some of these concerns, right? So if the incoming president comes in and says disgorge, which was a great verb, disgorge all of your delegations, they might not give, for example, the standing rules of engagement or something else that's out there in the world. So that was my first point. The second is a really technical one about Section 301, which is the statute that the paper talks about regarding how we do the subdelegations, right? So, as you say, right, the subdelegations need to be put in the Federal Register, and they can be made to a Senate-confirmed, presidentially appointed official, if memory serves. And I immediately thought of a number of examples from my time in government service where more than that was done. So, for example, most DoD regulations are not in the Federal Register. They're in directives and instructions that are on a DoD website, right? It's like you can go to the Executive Services Directorate website for the Department of Defense and find umpteen different regulations out there, and many of them contain delegations. But, they were at one point in the Federal Register, and they're no longer in the Federal Register, and that confuses me. And then some are in other documents that are harder to find, like Chairman of the Joint Chiefs of Staff instructions that you don't have the public doesn't have access to, or even in military plans, right? So if we're thinking about operational plans and documents like that are, as you mentioned in the paper, classified and have the additional challenge of the executive branch's longstanding opinion that plans like that should not be provided to Congress, right? The issues with I think oversight and transparency might even be more complicated. And then I can give you an example of in the counter-narcotics context, right? the equivalent of a Deputy Assistant Secretary of Defense, which is not Senate confirmed by any means, has been empowered to authorize the use of a lot of counter-narcotics funds to execute statutory grants of authority that have been made under Section 284. So it's a long way of saying I wonder if the problem is even worse than we might think. Okay, so those are my 2 points on Ashley's paper. I found the TikTok paper to be fascinating and fun and depressing all at the same time. So my first question, and these really are less questions and more 2 parts of the paper that I found to be particularly interesting and kind of almost like wanted to see more of as I was reading through. So one was just being really shocked by how confused we seem to be about the nature of our concern. And I think you were getting at this before, right? So like I made a list of things that we might be concerned about. So are we concerned about a risk to an individual if a malign foreign entity has access to U.S. citizen PII? Or do we care about the harm that might be visited upon a population in the United States based on aggregated information? Or do we care about like the nature of the foreign entity that has the access to this data? Is that tied to the uses that the foreign entity might make of the data? Does the kind of access that the entity has to like U.S. digital infrastructure, like really, is that what we really care about? Or like, does it just come down to the fact that we don't want China to have access to this? And if this was like Balo and it came from South Africa or like, Argentina or something, we wouldn't care. So that's, I raise that in the context of our general theme for the symposium, because it's really striking to me how little of a policy decision seems to have been made at any level. And I wonder if you think that makes this particularly susceptible to some of the non-delegation and major concerns we've been talking about today, because there's a significant domestic kind of component to all of this. And then second is, and again, you mentioned this already in the paper, is that it just seems, and I think this is a technical term, bananas, that we are thinking about the concept of group privacy first in the national security context, and not in a more general manner, which I know you've written about in the past, right? We have models for what that might look like in the GDPR. The model that we seem to be pursuing here reminds me much more strongly of the approach taken in the Chinese national security law, right? Where privacy is understood foremost as a national security concern that is disambiguated from the individual. And so, just 2 comments for you. Enjoyed both the papers just a ton.
Great,
So
thank you. Thank you very much. What I'm going to do right now is I'm going to allow our speakers to respond, because I know you probably have plenty to say. But while we're doing that, what I'd like to have is, if you're interested in giving a question, if you could walk towards the mics now, so that we're not sort of left wondering how many people would like to participate. It'd be great if you walked there now. And the next thing I'm going to do right before we turn it back to our panel is to announce the next password. And the next password is TikTok. TikTok. Okay, very good. So turn it back to the panel. Please do approach the microphones if you plan to have a question.
So, Chris, those are really helpful and provocative thoughts. The first one, this question about, is unit self-defense, basically the ability of soldiers in the field to respond in self-defense if they're just randomly out on patrol and someone shoots at them. That has to be right? And I'm not challenging that is something out there. One question that I need to do more work on and think through, and many have written about this, is whether that's actually a sort of form of the repel attacks power that trickles down through all members of the armed forces and maybe even some members of the CIA out in the field. So I need to do a little bit more research about that and think about sort of what is that source of the inherent powers that ends up on the pointy end of the spear. In terms of whether the problem is worse than I might imagine, what I'm trying to do in this paper is to come up with some way to kind of cabin the things that I'm most concerned about. And so at the beginning of part 3, I basically say, look, what I'm really worried about is those actions that, if taken, could implicate a resort to force against another country in the first instance. So the sort of jus ad bellum, for those of you who speak international law, less worried about the jus in bello. Some of your examples might be more jus in bello. But that is not an incredibly crisp line drawing, and so I think maybe I need to do a little bit more work to see if that's exactly the right place to slice it. But I don't gainsay the fact that there are delegations all over the place inside the executive branch, as there sort of has to be. And I'm just trying to think about the most costly ones.
Good, yes, go ahead.
Great. So let me respond to the first question that you asked about, how you read the paper and you came away wondering how confused the concerns are, and you listed an array of options of what the concerns might be. I think from the Trump and Biden administration's perspective, I think they would defend themselves by saying it's all of the above. That their concerns are really include going after an individual, going after a business, the advantages one business might be able to somehow get if it had that secret information, et cetera. The problem and I think on a general level, all of that makes sense. Personal data can be risky, can have those characteristics. So I have 2 big points that I kind of approach this with. First, TikTok is an odd choice. Most of what people do on TikTok is public-facing. It's not like Telegram, which is permitted in the United States and has very obscure origins and very obscure connections to the Russian government, but is still a massive communications platform in the United States. So it's just a weird choice to direct your cybersecurity energies at. Second point. The internet is inherently dangerous. I can spin you a story that the weather app on your phone or even your gaming app is dangerous. Everything is dangerous, and we can tell a story that makes everything that you do online dangerous. By the way, dealing with an Argentine company, what if that Argentine company is really a shell for another company, which is really a shell for a Chinese company, and China has all the data? You would have to vet everyone that you deal with on the internet all the time. It's impossible. So this is the level of, so you can tell a scare story about TikTok, but you can tell a scare story about any app on, any engagement online. Just being online is itself dangerous. Okay, so you're using your Wi-Fi right here. How do I know? And that those routers are probably made in China. How do I know that that's not all being picked up in China and you haven't been compromised, right? So at some point, this becomes so expansive an authority and so obscure a process that it really defies and it can be used. So one of the things we're going to say in our next version, we're not making a political observation about TikTok, which, by the way, will survive, and it's going to survive the next few years. Why? Because the Democrats rely upon TikTok. Okay, that's why it's surviving. That's why it'll limp on at least to the next administration. All right, and so the Republicans unilaterally disarmed in TikTok. The Democrats need TikTok. It will make it through. Okay, and so. But the same energies could be pointed to Telegram or RT or whatever other app that ends up favoring one party or another. And you can tell stories for everything online. So.
Yeah, and Chris, thank you for those wonderful and perceptive remarks. So absolutely about how confused we are about our concerns in this area. I didn't watch the TikTok hearings, but I read the transcript, and they're all over the map. But it's bipartisan disdain for the app, and one way that we kind of respond to this confusion in the paper. Namely in our kind of tentative sketching of a possible national security constitution for personal data, we call for specific evidence of the risks presented by an app or a platform to the public before the U.S. government can ban or restrict an informational app. So let's go, for example, to the concern aired at that hearing on March 23rd, 2023, about the Chinese government producing cartoons for Saturday morning. So actually, I lived in Berlin with my family. We then had a small child. And there we were at the American Academy in Berlin. It was wonderful. And we watched a lot of cartoons that, as it turns out, were produced back in the days of East Germany, right? Including, I'll never forget it, The Sandman. And so we survived, and they were really great cartoons. And there's also all kinds of content from the Czech Republic for family programming. And this is like old stuff that even by the time we were in on that sabbatical in 2002, they're like children's classics. So that would not survive, right? Like, we're worried about them producing cartoons unless there's something else going on. So that's one of our proposals. Regarding how it is strange, in fact, that this notion of group privacy comes in U.S. law and national security context, especially since so many of the scholars who've advocated for this in the kind of more generic information privacy literature have been doing it kind of more from the left part of the spectrum. And so, on the other hand, like in Europe, this has long been part of the discussion of privacy as a human right. And so going back to the German Constitutional Court in 1983, articulating a right to information self-determination and saying it's important not only for individual autonomy, but because a democratic society needs autonomous individuals who can participate in public life. So, and certainly from the American perspective, that may seem very vague, right? But it's there in European law, and it is strange that it comes in. And so we argue that the problem is it's so open-ended. We're worried about it. And just two kind of further dangers, I think, that we can talk about in terms of this particular kind of shift of authority to the executive branch is, one is what we call tit for tat for TikTok, which I thought was kind of a good phrase. But so we see this with potential threats to Apple in China. And so the fact that in our attempting to protect national security, we may not be thinking through implications for the national economy, which doesn't mean we shouldn't protect national security, but it sort of means we should be thinking about this in terms of, I guess, chess and not however we're thinking of it. And then finally, yeah, tic-tac-toe, exactly. So, and then finally, data balkanization, something that Anupam has been writing about for a while. And so implication of Project Texas is kind of Fortress America for sharing, for data servers. We see this in Europe to some extent already due to the GDPR and other elements in their law. So lots of U.S. companies just store all their data in Ireland. And it is a step back from the dream of an internet that was borderless.
Very good. Thank you. Yes, please. Okay. You can go first.
Hey, thank you so much. Thank you so much for speaking with us. I think you all did an admirable job of batting cleanup, as it were. This is a question primarily for Professor Deeks. So I wanted to ask about subdelegations to non-human actors. So this could be delegations to automatic, algorithmic, or artificial intelligence systems. You discussed the delegation of nuclear weapons authority to military officials by, I believe, President Eisenhower. This reminded me of what has been referred to as the dead hand system within the Soviet Union, which allowed for launching of nuclear weapons automatically in response to a perceived first strike. It's also not hard to imagine this being relevant in other contexts as well, such as financial transactions by sanctioned entities or engagement decisions by artificial intelligence that powers drone systems or other weapon systems. Should we think about these delegations differently? And what rules are in place that differentiate delegations to human versus non-human actors?
So it's a very interesting question, especially because Congress, some members of Congress themselves have proposed legislation that would preclude the president from, I think it's, I can't remember if it's using or spending money to develop autonomous command and control systems for nuclear weapons. So even our members of Congress are actually thinking about this particular question now. And so Matt Waxman and I had occasion to do a short blog post trying to think through this and whether the executive would make arguments that such a statute were unconstitutional. And in thinking through whether and how a subdelegation to a machine would be different from a subdelegation to an individual, one of the complicating factors would be the form in which the delegation would occur, right? So if part of what you're doing in a delegation is trying to capture as the principal what you want your agent to execute, we're used to doing that in the form of speech, in the form of writing, right? 3 U.S.C. 301 envisions it being in writing. If you're actually trying to develop an autonomous system that would activate when you yourself would have activated it as a human, you'll need some very sophisticated coders to accurately run through all of the different possibilities that you as the principal might have to would have had to confront in the real world. But you can also imagine certain upsides to that. Like if we were sophisticated enough to do that, then you'd know that the system would accurately reflect the principal's will. You can't always know that when you're a human delegator. You don't know that your agent will, in fact, execute the way that you want him or her to. So some costs and benefits, but I think it is a very underexplored area. But those kinds of questions are what got me wanting to understand how we currently think about it in the normal world, so that we're a little bit more prepared for the more technologically advanced world.
Very good. Yes.
Thank you.
And if you're thinking about a question, go ahead and approach the mics now.
I'll be quick, given the hour. A rhetorical question for Ashley and maybe a rhetorical comment. I was horrified to learn today of Eisenhower's subdelegation. I'd never heard that before. You said things are better today. How do we know that? And then the rhetorical comment, it seems that the results of subdelegation have another name in the media today, and that's the deep state.
Okay, so thanks. There's actually a fair amount of writing on the Eisenhower subdelegation, if you're interested. I think it's called the National Security Archive at GW, sought through FOIA a number of the actual memos that reflected the conversation with the president, the Secretary of State, Secretary of Defense, and so on. So those are fascinating documents. My understanding is that during the next administration, the president revoked that, and it was actually the subject of debate when he was rerunning for office. But how do we know that it is better today? Well, I'm not an expert on nuclear control, but by all accounts, we now have systems in place that make it much easier to maintain contact with the president at all times, the nuclear football, the dual key operations, and so on. So I think most people who are experts in this area do feel like we are in a better place than we were in the 7 messages. Just a footnote, the way the British do this is fascinating too. When the prime minister comes into office, the first thing he or she does is write basically a secret note given to 3 different people who control UK's nukes, and they don't open it during the administration unless they have to, and then it gets destroyed. So the Brits have their own system. In terms of the deep state, people like Rebecca Ingber have written about the way in which the bureaucracy operates, and recognizes that some perceive it as a deep state, others see it as valuable expertise that's accumulated over the years and serves as a useful check, sort of in the way I think Jean described in her response earlier. It is right that one way in which the individuals inside the government receive their authorities is down through delegations, but it's hard to see how it could be otherwise. So those are not the concerns that I'm trying to struggle with in my paper.
Hey, can I just ask a quick follow-up on the Eisenhower case? Were they all military? Did you say they're all generals? And did you say that any one of 7 could, or that they had to act as a committee and be unanimous? What was that like?
So I believe yes, they were all military, and any one of them they did not have to act as a committee.
Goodness. Scary.
Yep. So again, I think Eisenhower took a fair amount of time trying to articulate exactly how the delegation was worded, but it was not to his Secretary of Defense, who is a civilian.
Yeah. And that was constitutional delegation, the sync power, that kind of thing, right?
We assume so.
Yeah,
we assume so. I mean, I'm not aware of any statutes that would have
my next
facilitated
question
that.
is kind of about the statutory delegation. And it seems like, Congress acting in the public interest, because you've fingered a public interest here, a public interest in knowledge about how decisions are being made. I guess we can always question why Congress may not be working in the public interest. But my question is, why isn't Congress more precise in this area? Any thoughts on that?
Where's Andrew Keller? Hi, Andrew. So, I guess I'd say a couple things. One is, in a given case, Congress may delegate authority to the executive and not really care which actor inside the executive branch executes it. Feels like they have articulated enough what the policy is, and they trust that whoever ends up with the chair when the music stops will execute it correctly. Another thing I'll say is that there are a number of recent examples, whether we'll see more and more of this, I don't know, but a number of recent examples where Congress is building in a requirement for notification, which suggests to me that they worry that there are delegations out there that they're not aware of, and that they want to make sure that they do understand where these kind of higher profile delegations go. And then it's quite clear, and I talk a little bit in the paper, about how Congress could clearly prevent further subdelegations. And in fact, OLC has created a roadmap for this in its opinions, where it gives a couple of examples where it thinks that Congress has been completely clear that it does not intend subdelegation, and so it cites a couple of existing
those are
statutes.
generally complied with as well.
I don't have reason to believe that they're not. Yeah, especially if in those particular cases where OLC has identified those statutes as one that from which the president cannot delegate, I would be shocked if the executive pushed through, notwithstanding OLC's opinions on that. Yeah.
Great. Any other questions? Any other questions? Okay, I want to give anybody on the panel, from our commentators to our presenters, one more opportunity to add any point that you feel would be good to wrap up with.
I want to ask a question, if I can,
Yeah,
again to Ashley.
Sure.
So, for me, the idea of subdelegation kind of made me worried about who would own the decision, a kind of sense of responsibility. So if the decision is not being made, if I'm making the decision, but it's not, but I'm not the person whose name is on the decision, or if I'm the decision maker, but I'm not the one making the decision, it confuses everything. And it seems to be that in either case, I can point the finger at the other guy. And typically it'll be the guy, right?
So I think it is clear both in the OLC opinions and I think also in some court cases that the buck will still stop with the individual who was the delegator, right? So in these cases, if the president is delegating, he is still the person on the hook for the decision, regardless of what his agent does. So I still worry about the lack of knowledge at the time that the decision is made as to who's making the decision because of the classification. But if you're Congress coming in after the fact, I think you end up with two targets. You can call up before Congress and critique the agent for making a poor decision, and you can also call up the president for picking an unfaithful or a incompetent agent.
So I'm going to just press you a little bit more because I saw you speaking last week about cognitive limitations on people's, so cognitive biases and everything like that. And here I'm actually not talking about principal agent questions. What I really mean is a kind of sense of confusion about and a kind of willingness to say the decision is out there and it's not me who's really ultimately making it, so that therefore no one owns it. It's being made by the system, but not by me. Because as a decision maker, as the official decision maker, I've outsourced it.
Yeah.
And as the delegee, I'm not really the decision maker.
So that might be right. Right. I haven't studied the deep principal agent literature, which exists not just in the law, but in other academic areas as well, about whether agents feel as though they are mentally somewhat distanced from a decision that they are making as an agent, as opposed to the decision they would be making if they were themselves the principal. So it's an interesting question. I think what you're suggesting is the diffusion of responsibility that can arise from subdelegation, both on the part of the delegator and the delegatee, could give us yet an additional reason to be concerned.
Yes. So what Anupam and I are thinking about, and where kind of the paper ends, is coming up with elements for the National Security Constitution for personal data. And so anybody who has kind of suggestions or things that we should be reading or thinking about, I'd be so thankful for that. We go back to Harold Koh's work on this topic and the National Security Constitution, and his notion that although he concedes that the president will have a leading role, that it should be viewed as a shared power. We looked at Jack Goldsmith's work on accountability during the Obama administration. Among other things, need for media scrutiny, need for the judicial branch to be involved. So I guess green sprouts here in terms of the firmer regulations, although they give wide kind of definitions of what quote-unquote sensitive personal information is, at least this is a move towards some transparency as to what CFIUS is doing. But that's really kind of where we end, and what we're trying to think about is what are the best kinds of constraints that should be placed on this enormous congressional delegation over personal data and what we call the national securitization of personal data.
Good. And Chris, did you want to add something?
Very small point. Your question reminded me that the context in which I've interacted with subdelegations before was in the FVRA context, the Federal Vacancy Reform Act context. And I recall, I think, the nuanced OLC opinion about when authority might not be able to be delegated being important when we had an acting official in the position who couldn't execute those duties. And so that I think there's an overlap there that might be helpful in making sense of the OLC opinion.
Okay, anybody want to add anything else? If not, thank you very much for a really interesting panel, 2 interesting papers, great discussion, and thank you so much to the audience for your participation. I think you have, I don't know your name, but you have earned the best participant in the process the entire day long. So thank you very much for all your activity. Appreciate it. And again, thank you so much to Kurt and to Jack for the intellectual leadership in this, working with our students. It's just a terrific honor for them to be working with you. And I think we're having some final words now to close the conference. And good.